Hello everyone. Today we are going to discuss the concept of will and how to make a will. So often when we talk about a will, the first question that comes to our mind is how are we supposed to make a will? And what are the legal requirements that go into making a will? Why is it required? What is its utility? So these are often questions that come to one's mind. So I'm going to today try to discuss these issues and discuss why do we need a will, what are the essential requirements of having a will, and what are the key elements that we can include in a will to make it legally enforceable. So I would start by explaining the concept of will. Will is basically, as we know, a legal document which is communicating a person's final desires and wishes. And the person who's making a will is, in legal parlance or language, commonly referred to as testator. So we can refer to the person as maker of the will or testator. So a testator outlines what he wants to be disposed of. What he wishes to give away after his death, his intention as to how his property, both movable as well as immovable property, should be apportioned, should be distributed. And not only that, if he has a minor, then to whom the custody of the minor should go and how his estate should be looked after, or what other instructions he has for his legal heirs, that is, the ones that are left behind, his other family members, are all captured by this document, which is the last and final testament known as the will. So after understanding basically what a will entails, a question comes to our mind that how are we supposed to draft a will? What are the essential elements of a will? So as per law, the three most important things which go into ensuring that what we draft in terms of a will or a last testament is valid is that, number one, the will needs to be the intention of the testator or the maker of the will, right? So it needs to be the person who is making the will should express that he wishes his properties to be distributed in such and such manner, which needs to be clearly and precisely specified as to which properties he wishes to go to whom after his death, whether his family members or anyone else he wishes to give it, in what proportion, the particulars and details of the property, they need to be provided. Number two, after the intention of the testator or maker of the will, the second most important aspect is that the signature of the maker of the will should be appended after the last sentence of the will. And this signature should then also be attested by two independent witnesses. Now, why I say independent is that it should not be the case that preferably the beneficiaries of the will should not be the ones who are signing the will. It should be some independent witnesses, in the sense it could be somebody who knows the testator, in whose presence basically he signs the will. And apart from this, of course, another very important stipulation which goes into making a will is that it needs to be given free of, it should be free of any coercion or any undue influence or any such disability of mind or body which prevents the person from giving it in his full mental capacities, or what we say as full hosho awaz in Hindi. So that should be there, that he's making the will, a stipulation or clause should be there that he's making the will free of any undue influence or any other coercion, and he's making it of his own free will. That is, he is not being pressured into making this will by anyone else. Apart from that, another important aspect that we need to discuss here are what are the key elements, aspects of will. So these are the legal requirements that you need to comply with to ensure that a will is valid. But even before coming to key aspects of a will, it is to be noted here that a will is not necessarily required to be made on a registered, I mean, a stamp paper or any such other legal formality. It could be on a plain piece of paper as well, as long as it complies with the three requirements that we spoke about earlier, that it should be number one, signed, duly signed by the testator or maker of the will. Secondly, it should be done by in his own senses and free of any coercion or undue influence. And finally, it should be signed by two independent witnesses. So apart from these three legal requirements, this will could be on a plain piece of paper, which could be even an unregistered, not even necessarily a stamp paper. It could be an unregistered will also. But this is the bare requirement. However, this is always recommended that if possible, we should have a registered will, and it is a better option. So that is one aspect of it. Moving on, there are certain key aspects of a will. So after we have, till now we have understood what is basically a will, and now we have also covered what are the legal requirements of a will and how it is, what is the modality of making a will. But what needs to be incorporated in a will, what needs to be covered in a will, could vary from a person to person, but basic tenets of what could come under key aspects of the will, I am just trying to discuss those now. So number one, most important is that whoever is making the will, he needs to put in his details, right? Like his name, like his age, address, and any other pertinent details pertaining to the person who's the maker of the will or the testator of the will needs to be there in the will. Number one. Number two is the intention of the testator. There has to be an intention of the testator that he wishes to give his property after his demise in the future. The intention is a future intention in a particular manner. And it should not simpliciter or simply be a narration of facts or somebody else's wishes. So for instance, an example of narration of facts or somebody else's wishes would be, I say that my mother wanted this to happen, or my father wished that the property should go in a particular way, and hence I am also saying this, stating the same. So it should be the testator or the person who's making the will. His wishes should be captured. Moving on, the next point would be the subject matter of the will. To break it down, basically a will can only be with respect to the property over which you have a legal title or a legal right. It could not be with respect to some property which is in a third party's name, somebody else's name, or a property which in all likelihood is supposed to come to you in future, which may come to you in the future. So we will not play on these sort of possibilities, but we can only incorporate property with respect to which we have a clear title, with respect to which we have a clear legal interest. That is, we own a property. Only that property can be included in the list of properties that you wish to distribute after your demise in your will. Now, the next point that I wish to discuss refers to the point number 4, refers to details of subject matter of the will. So, the details and descriptions of the properties which one wishes to pass on after his demise needs to be clearly mentioned, and to whom such properties we wish to give, that is the beneficiary. Beneficiary is basically the person to whom we wish to give the property. That needs to be also clearly mentioned. Now, speaking of beneficiary, the next point takes me to point number 5, which is beneficiary details. The details of the beneficiary, just like the details of the person who's making the will, that is the name, the age, the address, and also the relationship of the beneficiary, if at all the beneficiary is related. For instance, he is a son or a daughter of the maker of the will. That needs to be also incorporated in the will. Now, the next point is with respect to the desires to be carried out in effect after the death. So it is basically again relates to the intention of the testator. It should be clear that the person who's making the will intends that the arrangements as he stipulated with respect to division of his properties and his last wishes should be carried out post his passing away or death. Now, point number 7 that I wish to discuss, another key important point is appointment of guardian. So, for instance, if a will is to be in favor of a beneficiary who is a minor, meaning a person who's in whose favor you're writing, maybe your son or a daughter who is not yet attained the age of 18 years of age, then in that case you need to have a provision for appointment of a guardian. A guardian is a person who will take care of the property or the movable or immovable property which you wish to give to your minor beneficiary until that minor beneficiary attains 18 years of age. So you may responsibly choose a person who you think will be able to manage and best protect the interest of the minor beneficiary in such a case. Now, another key aspect of will relates to an executor of a will, which is the next point that I wish to discuss. Executor of a will is basically a person who will ensure that the distribution of property or the last instructions as mentioned in the property of the maker of the will are carried out as per his last wishes. Now, it is important to note here that it is not mandatory under the law to have an executor appointed in case of your will, but it is sometimes often advisable to have an executor of the will who ensures that your last wishes are duly complied with. Now, I had mentioned earlier a point about towards the end the legal requirement. So here it's also covered as a key point that you need to sign the will towards the end clearly and legibly with your name and the date, so that it is clear that you are the one who is intending to give effect to this will and it is your will, your last will and testament. So that should be clearly mentioned. Now, the next point that I wish to discuss is with respect to exclusions. So there are certain exclusions that basically state that your property cannot be given away in certain type of property such as ancestral property or joint family property or HUF property, which is Hindu undivided family property, cannot be given away to others because others may also have a stake in it. So it may be common to others as well, like ancestral property, which is to be divided between 3 sons, cannot be given away entirely to one son. So that is the concept, because in such a case, this will become void or unenforceable, in simple words. The next point that I wish to discuss is alteration or modification. Something to be kept in mind is that a testator or the maker of the will can make changes in the will or can rescind or do away with the earlier will and come out with a fresh will only during his lifetime, and after that, of course, no changes or alterations are permitted as per in the will. Now, the next point, that is the last, which brings me to the last point of the key elements of a will, is force or coercion. So, of course, it is important that a will, a key element of the will, you see, as well as a legal requirement, is that it should be made freely. There should not be an element of force or coercion. And it is therefore also advisable to have a clause to this effect that, this will has been made free of any coercion or pressure or undue influence. And also add to this the point that a will, something to be kept in mind is a will which is made under intoxication, or when you're not of a sound state of mind or body and you do not have the ability to give consent, which takes away the consent, or in legal words, it vitiates the consent. That is, it takes away the consent, the legal sanctity of a consent. And then again, the maker of the will, his consent will not be held to be valid, and this will be a void or unenforceable will in law. So we discussed broadly the points relating to a will, the key elements of a will, the legal requirements of a will, what a will entails, And which brings me to the last segment of this episode, as to why we should have a will in the first place. So you see, often having a will ensures that there is clarity or lack of ambiguity with respect to division of assets after the death of the maker of the will or the testator, and a person doesn't have to worry about family feuds or disputes subsequently. Basically, it minimizes the chances of such things happening and ensures clarity with respect to the other family members or the persons mentioned in the will as to how much or what they are supposed to get. And it also ensures, it is also a crucial tool to ensure that there are no bogus claims made on the estate of the deceased or the maker of the will. And also, one last point which we need to keep in mind is that it ensures that your last wishes are respected and your dependent children or other family members are provided for and you get a say in it. So it is better that it ensures a estate planning, and it ensures that you are not caught unprepared. Especially your family is not caught unprepared subsequently, and that there are no legal feuds or disputes. Which brings me to the end of this segment. I hope it was informative, and I would like to hear more about your comments and how it was for you. Please do share your comments and inputs on the same. Thank you.